Welcome back to the Legal Alternative Podcast with me, Sam Pawson, joined us out by Nils. Nils, how are you?
Very good stuff. How are you?
Yeah, good. As we'll discuss later, a bit achy after the marathon, but not bad. We are obviously recording remotely today, but no, it's all good. And I think we've both got some relatively topical and interesting things to discuss.
I think so, yeah.
So,
Okay, to this.
Yeah, so I think I'll kick us off because I think I especially want some time for your update. I'm going to talk about something we have mentioned before, but it's always a timely reminder, which is worker status. It is timely because as we speak, there is a tribunal claim being in the London Tribunal with Just Eat, there are 7,000 couriers at Just Eat who are group claim challenging their worker status. So for regular listeners and people who are familiar with this topic, this is running the same lines as quite a number of high-profile cases, probably the most high-profile of them being with Uber drivers, where they held for the drivers to be workers rather than self-employed individuals. So this is going down the same kind of tests and justifications as that Uber case. Relatively well-established case law. They do all depend on the facts, but obviously Just Eat a number of high number of couriers, 7,000. So I'll talk about kind of the consequences for them if they are held to be kind of the workers. Where most of these cases go, just as a very quick reminder on worker status, three current statuses you can either be self-employed, you can be employed on the other end, or there is this middle category of worker where you enjoy some benefits that employees would be: minimum wage, holidays, absence, but you don't have the protection under the Employment Rights Act for unfair dismissal being the critical one. So important case, and I thought it'd be a timely reminder. Obviously, we haven't got the facts and how the case will be determined, but the case law is well founded. So I thought it'd be a good opportunity just to quickly review what the tribunal will be looking at in these cases in terms of the tests they use. If I'm being technical, it's Section 2B of the Employment Rights Act, where we're looking at to establish someone's status. So there is a three kind of limb test, but then there's something else in terms of the relationship that the court and tribunal will look behind. Simple kind of test from the outset is the three components to be a worker is there must be a contract, there must be personal service, and there must be some form of business relationship between the worker and the employer. So relatively simple test. And the starting point really is that contract. And what does the contract establish? So is it a contract of employment or workers, or do the parties believe that this is a self-employed contract of services where self-employed will provide their service to an organization? That is the starting point. But that often in these cases is not the end point, because yes, the tribunal will be heavily influenced by what the parties set out in their agreement, but they will look behind that agreement. So in these type of cases, I'm sure there is an agreement with the Just Eat Couriers that says they are self-employed, and it is it's a contract for them to provide their services. So what the solicitors acting for the couriers will have to establish is the reasons why that the tribunal should look behind that contract and look to the actual relationship between the parties. If the tribunal is persuaded to do that, what the tribunal then looks at is a number of key factors that they use to determine whether someone is a worker, an employee, or self-employed. I'll kind of go through some of the key ones, and one of the key ones is if individuals can have a right to substitute. So if this is a contract of services, and you as an organization are providing a service, in that relationship, you often can substitute. You can appoint someone, you can have someone work for you to carry out that service. And there's a right to substitution in most of those agreements. In these cases, historically, there isn't a right to substitute. So if you're the Uber driver, you can't get your mate to do the pickup. There is a requirement for that kind of service to be provided by that individual. So the right to substitution is often a critical one, and where these couriers, again, start to get to establishing their status. Other matters they will look at is the degree of control that the organisation has, and the party's requirement to work and establish their rules. So that's if do you have handbooks, processes, policies that you are trying to ask these people to follow? Are you providing uniform? Are you clearly identifying them as an individual who solely works for you, and that degree of obligation for the individual to carry out the role? So that's where with couriers it becomes quite interesting. In terms of that obligation to carry out their role, do they have to accept the fare? For example, are they obligated to do that? Obviously, the companies argue no. They're free to take the job or not take the job, and if they don't want it, someone else will take it, and that's where these cases really do boil down to the facts of the relationships. The historic Uber cases, they can point to a requirement to take a certain amount of fares, of what they're doing when they're waiting, if they can work for other organisations. Often Uber drivers now do work for more than one. So whether that starts to be decided differently now, but at the time it was more of an exclusive relationship where they work for one provider. So all of those things will be decided and looked at in this case. The instinct suggests it will probably go down on the finding of a worker, as with the historical cases. But it will, as I say, if it is being contested, so you think Just Eat would be relatively comfortable with their defence, and it will, they will be challenging those points, in particular about obligation to carry out the role, can create problems with dual employment, because again, it's a Just Eat, it's an Uber Eats, it's a Deliveroo. You often get couriers acting for all, more than one company. So if are you employed by all of them or a worker for all of them? So it will create, obviously, interesting challenges. Obviously, the financial issue for Just Eat in this instance is if you find that they are a worker, what comes with that is obviously national minimum wage, leave, sickness protection, potentially some pension contributions. So those type of things will kind of go to added cost, whereas if obviously they're self-employed, none of that will apply. So decent stakes at hand, and we'll see how it is reported, and obviously as soon as we get a decision, we'll share it on the pod. Any views, Nils?
I've only appeared in the Employment Tribunal, I think 2 or 3 times, doing my own advocacy. But one of them was on worker status. I think it was to do with an individual who was working on some gas pipes a long time ago, maybe 2012, 2013. And since then, I've done IR35 work where the tests are quite similar. The tax tribunals, they look at the contract on the face of it and then determine what they believe to be what's called the hypothetical contract. So they will look at the facts and say, actually, this is what we believe the arrangement was between the parties. I don't know if the Employment Tribunal does that.
I think it's broadly the same, as you say. It's the starting point will be the contract, but then they will look, actually, what is the relationship really like, and what is that? You said that hypothetical agreement.
I always thought that was a good way of doing it when I read tax judgments, because it was really well structured and you could get a very clear sense of what the tribunal had decided. And
I think it is the same with IR35. Substitution is often very key, and where organisations get themselves into difficulty. Yeah. So it will be really interesting to see where it goes. But as you say, always quite technical, but interesting cases.
Yeah, I suppose the difficulty for a lot of these organisations would be the regulation. surrounding it. So if you are a taxi driver for Uber and you are registered with that particular council, to then say, well, you can get your mate in to do it is not feasible. And that's where the domino starts to fall down, isn't it?
It does. I think the final point, as always, is there's been talk for a while of some simplification of these status. We're not there yet. We are having changes next year, which will make this even more difficult for organisations in terms of if you are helping people to be workers, 0-hour casual workers, they then have a right to request permanency of hours.
Yeah.
You could see an issue for couriers that can point to regular hours and then say, well, I want to be paid for these and these are my regular hours going forward. And if there isn't the custom, there isn't the custom. So that's going to be really difficult. And then if we get an employment status rather than the worker status, you'll also get 6 months of, then you'll have unfair dismissal rights. So these are going to become really, really critical decisions.
Yeah, absolutely.
Fabulous. So I think we're talking, well, it's not record fines. You shocked me on a little pre-chat. So yeah, your update, Nils.
Yeah, so a very big fine. And I think that there's a couple of takeaways from this for us as practitioners, but there's also an underlying message to our client base and the people who listen to this pod that anti-money laundering, as well as bribery protection and I could go on and on with various different pieces of legislation that businesses have to comply with. It's not just a box ticking exercise. It does have very serious real world consequences. And this is related to failure to prevent bribery. So a company called, first of all, it's the Serious Fraud Office that brought a prosecution against a company called Ultra Electronic Holdings Limited, which was formerly a PLC. So on the 1st of this month, I won't say his name because it wouldn't be fair, but our judge approved what's called a Deferred Prosecution Agreement between the Serious Fraud Office and Ultra Electronics Holding Limited. So they are a manufacturer of electronic systems for international defence and the aerospace market. So obviously very niche, probably very high value. The company acknowledged accountability for failure to prevent bribery under the Bribery Act 2010. These are public documents, so the actual Deferred Prosecution Agreement, the Statement of Facts, the undertaking and the indictment have all been published by the Serious Fraud Office. What the agreement requires is that Ultra Electronics Holdings pay a whopping £10 million financial penalty and £4.8 million in costs within 30 days. So thick end of 50 million quid within 30 days. They're also going to have to provide yearly reports for the next 3 years to show the effectiveness of their anti-bribery and compliance program. Comply with strict conditions that demonstrate genuine and sustained reform, which will be given court scrutiny. So what actually happened is the Serious Fraud Office opened an investigation into this company in 2018. So this goes back 8 years, following the company's report of suspected corruption offences relating to conduct in Algeria. And then the investigation widened into all jurisdictions in which it operated in 2024. The company operated in 2024. So the actual agreement that's been entered into between the SFO and Ultra Electronic Holdings relates to failure to prevent bribery in connection with 3 public sector contracts sought through the use of agents. There was some fairly powerful mitigation, to be fair to the company. The judge attached particular weight to the fact that the company, following its acquisition by Advent International LP in August 2022, was a different entity from the one that had committed the original offences. Different management, different personnel. And the court also emphasised the value of self-reporting with any offence. So it could be a RIDDOR, it could be something like this, it could be money laundering. Self-reporting was held to be key. And the penalty was actually calculated, and this is where, for us, it's helpful as practitioners, a 300% multiplier, the harm figure for each count, 45% discount for admissions and corporations, which is quite significant, and a 10% totality reduction. So there's some really useful information for us as practitioners in terms of how the agreement has been reached, or in terms of looking at it and arriving at the final figure. That's for us as practitioners, though. I think for me, what's really key for clients is 2 things. One, there's been quite a nuanced approach to this case, and that the cooperation discount was key. But actually, it's that people do get fined for not complying with what's seen as red tape. And whether we agree with it or we disagree with it from a political point of view, it's there. It's probably not going away. This is exceptional, probably, in terms of the result, but this does happen. Companies are prosecuted for this, and if you're not on top of this, hopefully you never end up where you're getting a £10 million fine, but there are real-world consequences for this, which this case highlights nicely, I think.
Yeah. And as you say, it could have been a lot worse. You know,
45% reduction.
45, so this is
55.
So it could be 20, this could be 20 plus million.
Yeah.
And I suppose that's the lesson, isn't it? That it's the admission and the, for want of a better term, the plea bargain that they've done. This is, we accept him, hold our hands up. We've reported ourselves. We've got it wrong, and then mitigate their loss as best as they can.
Yeah, I mean, there was a little bit of so there was self-reporting, but then there was some late disclosure in relation to some misconduct that happened in Oman. In 2022. So they would have got more credit, but for that, they could have been eligible for a full 50% of discount, but didn't get that. So even following self-reporting, it's important that you continue to think about the candor that you should show to the prosecution. But yeah, a huge fine, absolutely huge, and a lesson for everybody, hopefully.
Which brings us nicely on to kind of what we've been up to. And as I said, I've bit stiff and achy today after the half marathon. So it's my fourth in total, either half or full. So I don't know if you've ever been to the Leeds one, Nils. It's a wonderful day. Start and finish at the stadium. And somehow, despite it being a miserable weekend, the sun appeared for 4 or 5 hours. So it was massive crowd as always, which is always helpful when you're plodding back through Headingley and getting cheered on. So no, wonderful day. Great to see, friends at the Rhinos as always, out in numbers. Kevin, JJB were running again as always, much quicker than I do. So no, really good day. Are you? Have you been up to anything interesting?
I did a mere 5K yesterday.
You mean 5K?
Yeah, so I think embarrassingly, I'm a little bit sore today. But I think that's the one run that still interests me. I think I've ticked off all the bucket list runs that I'd like to do, but that's the one run that I'd still like to do. So maybe next year I'll have to sign up for it.
Fabulous. Good stuff. So that's it for today. We'll be back next week. So thank you from me.
And from me, take care everyone. Bye-bye.